Okay, so today I'm going to switch things up. I'm going to talk about Melton v. Toomey. Um, right up front, I'm not an attorney in Texas. I'm not licensed in Texas. I'm only licensed in Florida. So I'm talking to you as a lay person, just discussing a case I found interesting and may be something someone in Texas dealing with child support wants to read about. Okay. And why might you want to read about it? Well, again, I'm the owner and creator of yesyouneedalawyer.com, and I believe most people need to hire a lawyer, or at least need to talk to a lawyer about their case. So, one of the things we commonly get asked as family law lawyers in Florida, and it seems to be something that gets asked a lot about in Texas, is how do we modify an order of child support? Well, there's a lot of case law to that effect, or a case law that deals with possible modification. And Melton v. Toomey is one I found to be very important when I was writing about child support uh, under my main thing, which I'm going to have posted in the links, where let's say you're from another state, there may be information related to your state in that material. Like if you're from Minnesota, Missouri, I tried to put together material relevant to all 50 states. So, So one of the issues the mother had was she claimed she was discriminated upon the fact that she was a woman. Um, the court pretty much, in my opinion, if you read the court case law opinion, just kind of disregarded that argument. And one of the things that's interesting to me about Texas is they decide their issues by jury, which in Florida we don't commonly have that. I don't know any family law lawyer that's ever had to deal with a jury deciding a case. It's always usually just been a judge. So that's one of the big, huge difference between Texas and Florida. Um, but some of the things I think that's important here is the father used a partial record. Okay. And one of the reasons why I think partial record is important because basically whatever is not touched on in the record you put before the court, the way I read the case opinion, this is something you'd want to discuss with a Texas lawyer, is what's not touched on is then presumed to be have been ruled on correctly in the lower court. So you may have elements in this part of the record that you didn't provide before the court that may be crucial to whether or not your case is decided. So that to me is very important as it goes to appeals. Okay, so Melton v. Toomey to me is very educational on appeals, especially if I'm on the other side, if I'm the appellee, all right, and then someone comes up with a partial record and they're missing critical elements from the record, I can then raise that in my counter argument, basically, like, hey, look, no, he didn't. The rest of this, basically by his own admission or failure to state, would have been in the rest of the record. So thus, there's a correct presumption, and he's not raising enough elements or issues to prevail on his appeal. That to me is basic, just a massive hindrance that I personally would want to avoid. Now, again, that's something to discuss with the lawyer having a free consultation with. But to even decide whether or not there can be a modification of child support, there has to be determination whether there's been a substantial and material change, okay, which requires the comparing of financial circumstances of the child and the affected parties at the time is ordered entered with their financial circumstances at the time the modification is sought. Now, what I think is really important is income alone is not enough. A change in income alone is not enough to say there's been a change in financial circumstances. Okay. Because otherwise, people would be going, oh, she got a 5% raise or a 3% raise. I need a modification. And I think the courts in Texas want to avoid that. In Florida, we have a substantial burden. So basically, if someone just got a 3% raise, you're not running back to court typically for a change in child support. Um, Someone's income went up 10%, you might want to go back to court. 15%, definitely. Um, And then the other grounds in Florida might be that they're taking less time sharing than they're supposed to. That reaches a substantial change from what was originally ordered. Why? Because less time the other party has a child. That means more time the other parent is having, the more money that parent's having to spend on feeding and clothing the kid, essentially. Right? In Texas, I haven't seen that yet. As far as the custody, or what we in Florida call time sharing. Okay. But the issue of the income is also something you'll see in the interest of DH modification of child support requires evidence. That's another case. So when I wrote the child support section for Texas, all right, I cited a bunch of case law. And why am I bringing that up? Because you got to have stare decisis. All right, it gets complicated. It's not just one single issue. Rarely is there any kind of silver bullet. You know, people are like, oh, just write me a motion and I'll go to court. Lawyers don't do that for a number of reasons. So, I mean, this is really just trying to bring in some of the complexity that goes into the practice of law, and why I think you need to talk to an attorney before you're like, hey, I want to do a modification. Well, maybe if you have a free consultation and your only point is, well, hey, my income went up or down, that lawyer, them being licensed in Texas, because I'm not, and I have to state that, because I don't want anyone going, oh, this guy was pretending to be a Texas lawyer. No, I'm just a lay person giving you some information. You know, it's not legal advice. It doesn't create an attorney-client privilege. But you might want to discuss with the attorney during the free consultation. Well, hey, these are the changes in my circumstances. Does this meet this burden of substantial material change for modifying my child support? Okay, so that's really why I like this case. There's the appellate thing with the issue of the partial record, and it's really starting to me, it helps establish the floor, some of the basic criteria for modifying child support. So in the absence of substantial material change, if your only change is the income, then you might be barking up. You might be facing some difficulty. You might need more to show what the change in financial circumstances are. Okay. And also, one thing that's not mentioned here, but I think you'll see in other case law is, does the change also serve the best interests of the child? You paying less does not necessarily work in the best interest of the child. But again, these are all reasons why you want to talk to a lawyer in Texas when you're pursuing child support modification. Okay? Thank you.